Kenya's High Court quashed a tax measure meant to bankroll President William Ruto's campaign pledge to build affordable housing, saying it was unconstitutional. A mandatory 1.5% housing levy for employers and matched by employers was declared discriminatory and unfair because it only applied to those with formal jobs and not the informal sector. Judge David Majanja said. The three-judge bench led by David Majanja said that the pending the determination of an application for an appeal against their judgment, there should be a stay of execution until January 10, 2024. The decision to issue a stay order arose from an application by the Attorney General through lawyers George Murugara, Mahat Somain, and Charles Mutinda on grounds that the state wants to appeal the decision of the whole judgment of the court. The application by the state was opposed by lawyers Evans Oganda, Frederick Ogola, and Ochieng Odinga. A three-judge bench had earlier declared the housing levy as unconstitutional for lack of a comprehensive legal framework.
Enjoys the prerogative and latitude to impose taxes as a means of achieving the objective of realizing the right to housing. They did not answer why the tax falls upon employed formal workers as opposed to other taxpayers or non-taxpayers. In Okello and another versus National Assembly and others, Odunga J stated that taxes need not look the same and selective taxes may be applied to different actors for different reasons, such as to address distribution and equity. Hence, the tax need not be similar to another for it to be rational and discrimination. We add that for any legislation to pass the rule of law test, it must have a rational connection to a legitimate government purpose. Otherwise, the tax legislation would be arbitrary and unconstitutional. It's therefore the duty of the state to provide a rational explanation for the manner in which the tax is involved. In absence of a rational explanation for the manner in which the housing levy was enacted, we can only conclude that the respondents took the easy path of least resistance, as taxing employees. Informal employment is easier. It is also the respondent's constitutional responsibility to create a broad, efficient, fair tax system that complies with Article 201(b)(1) of the Constitution and the taxes levied against persons in formal employment to the exclusion of all other non-formal earners to support a national policy without a clear justification is discriminatory, irrational, and arbitrary in violation of 27(201)(b)(1) of the Constitution and therefore unconstitutional for those reasons. In the Court of Appeal, in Kenya Revenue Authority versus Waweru stated that explained the principle of unfair taxation under 201(b) as follows. On the issue as to whether the imposition of minimum tax results in unfair and contrary to Section 201, the threshold for fairness is ensuring that everyone bears their fair share of taxation and pays the correct amount, which is seen to be fair by vigorous pursuit of tax avoidance and evasion. The petitioners have assailed the housing levy on the ground that it will result in lowering salaries of judges, hence is in violation of Article 164 of the Constitution, as well as the commissioners and holders of independent offices in contravention of Article 258 of the Constitution. These provisions that protect the remuneration and benefits are intended to safeguard the independence of judges of superior courts, commissioners, and independent officers by insulating them from attempts by the political branches to influence them by reducing or threatening to reduce their remuneration and benefits. The petitioners have not demonstrated how the housing levy directly affects the salaries and benefits of protected officers, state officers, and how it violates Article 160 and 258 of the Constitution in that regard. Our reading of Article 210(3) of the Constitution is clear. It provides that no law can exclude or authorize exclusion of state officers from payment of tax by reason of the office of that state officer or the nature of work of that state officer. The petitioner's submission that